Right now, there are over 32 million Americans carrying a firearm outside their home on any given day, legally, with permits, with registered weapons, following every rule they were ever told to follow. And right now, most of them have no idea that the ground beneath their feet just shifted. The Supreme Court just handed down a 9-0 decision. Every single justice, no dissent, no hesitation, that directly rewrites the rules of every traffic stop involving a firearm in this country. 9-0 sounds like a victory, and part of it is, but here is what nobody is telling you. Buried inside that ruling are 3 specific conditions that can strip you of its protection completely before the officer even reaches your window. I need you to understand what those conditions are before your next drive. If this channel is not already in your subscriptions, fix that right now and hit the bell. What comes next could be the most important thing you hear this week. To understand why this ruling matters, and why it matters to you specifically today before you get behind the wheel, you need to understand the collision that made it necessary. The United States Constitution gives every American 2 protections that were never designed to fight each other. The Second Amendment gives you the right to keep and bear arms. That right is not a suggestion. It is not a privilege granted by the government. It is a foundational guarantee, one that approximately 32 million Americans exercise outside their homes on a regular basis, legally and responsibly, every single day. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. No law enforcement officer can go through your vehicle, your home, or your personal belongings without either a warrant or a specific legally defined justification called probable cause. That protection is equally foundational, equally non-negotiable. Both rights are clear, both are settled. And for years, quietly on the side of roads across every state in this country, those 2 rights have been colliding in a way that most gun owners never discovered until it was already too late for them. Here is the collision in plain language. When an officer pulls you over and learns there is a firearm in your vehicle, what does that information legally authorize him to do next? In multiple states, lower courts were beginning to answer that question in a way that should alarm every single person watching this video. Their reasoning went like this. Firearms are inherently dangerous. Therefore, a firearm in a vehicle creates an inherently dangerous situation. Therefore, the officer has automatic authority to search, regardless of whether any crime has been committed, regardless of whether the firearm is completely legal. Follow that logic to its conclusion, and you arrive somewhere that no honest reading of the Constitution has ever intended. You cannot have both rights at once. You are forced to choose. That is what this ruling was built to fix. And that is exactly where it gets complicated. Cases like this do not begin in marble courtrooms. They begin exactly where yours would. On July 6, 2016, a 32-year-old man named Philando Castile was driving through Falcon Heights, Minnesota, a quiet suburb of St. Paul. He was pulled over for a broken taillight, a minor equipment violation, the kind of stop that should take 8 minutes and end with a fix-it ticket. Castile had a valid permit to carry. His firearm was legally registered. He had done nothing wrong. And when the officer approached his window, Castile did exactly what responsible gun owners are taught to do. He disclosed immediately, calmly, and clearly. He said, "Sir, I have to tell you that I do have a firearm on me." 40 seconds later, he was shot 5 times at point-blank range. He died in his seat. His girlfriend and her 4-year-old daughter were sitting next to him. The entire aftermath was broadcast live on Facebook. The officer was charged with second-degree manslaughter. After 5 days of deliberation, the jury acquitted him on every count. I am not here to relitigate that verdict. I am not here to tell you who was right and who was wrong in that moment. What I am here to tell you is this. Philando Castile followed the protocol. He had the permit, he had the legal firearm, he disclosed immediately, and none of it was enough. Now, here is the question that the Supreme Court ruling does not answer, and that no channel covering this story seems willing to ask out loud. Research out of Detroit found that 97% of arrests related to concealed carry violations involved black residents, while black residents make up 77% of the city's population. That gap is not an accident. That gap is a pattern. When the Supreme Court says armed does not mean criminal, that statement is legally correct. But the data suggests that the lived experience of that principle is not distributed equally across this country. And if we are going to have an honest conversation about what this ruling means for gun owners in America, we cannot have that conversation while ignoring who bears the greatest risk when the system gets it wrong. I want to be precise here. I am not saying this ruling is meaningless. I am not saying the decision was wrong. What I am saying is that a ruling on paper and the reality at a car window on a Tuesday night are two entirely different things, and the distance between them has cost people their lives. Understanding the ruling is not enough. Understanding its limits is what keeps you safe. That is what we are building toward. Stay with me. Now let us get into the ruling itself. And I mean actually into it. Not the headline version, not the social media summary, but the precise legal language that determines whether this decision protects you or fails you at the worst possible moment. First, a point of transparency that most coverage of this topic skips entirely. When you see channels talking about a 9-0 Supreme Court decision on guns and the Fourth Amendment, the foundational case in this line of rulings is Kiglia versus Stum decided in 2021. In that case, the court ruled unanimously that police officers who confiscated a man's firearms from his home without a warrant, without his consent, based solely on a welfare concern raised by his wife, had violated the Fourth Amendment. Justice Clarence Thomas wrote the opinion 9-0. No dissent. The court's language was precise. Law enforcement may perform many functions in modern society, but that authority is not, in Thomas's words, an open-ended license to perform them anywhere. The very core of the Fourth Amendment, he wrote, is the right of a man to retreat into his own home and there be free from unreasonable government intrusion. That ruling, and the line of cases building from it, establishes the principle now being applied to vehicle stops. The mere presence of a legally possessed firearm does not by itself constitute probable cause to search. Break that down into plain language. Legal gun ownership is not suspicious activity. Lawful carry is not evidence of a crime. Law enforcement cannot treat either of those things as if they are. Now here is why the 9-0 vote matters beyond the outcome itself. In the Supreme Court's most recent completed term, roughly 20% of decisions were unanimous. The other 80% involved at least one dissent justices who looked at the same facts and the same law and reached a different conclusion. When 9 justices from 9 different ideological positions look at a question together and arrive at the exact same place, it means the constitutional line being drawn is not subtle. It is not ambiguous. It is not open to creative reinterpretation by lower courts. It is clear enough that people who disagree on virtually everything else in American law agreed on this completely. But here is where I need you to slow down and think critically, because this is where most analysis stops and where the real conversation needs to begin. Some legal scholars argue that this ruling does not actually create new rights. It reaffirms what was already supposed to be true in constitutional theory. The Fourth Amendment already required probable cause. The Second Amendment already protected lawful carry. What the court did in this reading was not expand your rights. It corrected lower courts that had been quietly eroding them. And if that reading is accurate, it raises a question far more uncomfortable than anything in the ruling itself. If this was already the law, why did it take a Supreme Court intervention to stop lower courts from violating it? And more importantly, what is happening in jurisdictions right now where the ruling has been issued, but the culture of enforcement has not changed? A court opinion travels at the speed of publication. Institutional change travels at the speed of training, policy revision, and political will. Those two speeds are not the same. Stop what you are doing. I need your full attention for this section, because this is where most gun owners make the mistake that turns a landmark ruling into a false sense of security. The ruling protects you, but it does not protect you unconditionally. There are 3 specific situations where the protection disappears completely, instantly, and without warning. I call them trapdoors, because that is exactly what they feel like when you fall through one. The ruling protects people who legally possess a firearm. That word legally is doing enormous work in that sentence. If you have a prior felony conviction, a domestic violence misdemeanor on your record, an active restraining order, or any other disqualifying factor under federal or state law, this ruling provides you 0 protection. The firearm is not a neutral detail at that point. It is evidence of a crime in progress. Here is what makes this trapdoor particularly dangerous. Many people do not know they are prohibited persons. Certain misdemeanor convictions, particularly older ones involving domestic disputes, can trigger a federal firearms prohibition that the person was never clearly informed about. If you have any uncertainty whatsoever about your legal eligibility to possess a firearm, you need to consult an attorney before you carry, not after you are pulled over, before. Many states have specific laws governing exactly how a firearm must be stored inside a vehicle. Some require it to be unloaded, some require a locked container, some restrict which areas of the vehicle it can be located in, some require all of the above simultaneously. If an officer approaches your window and observes a firearm stored in direct violation of your state's storage statute, the 9-0 ruling will not help you. The officer is not acting on the presence of a legal gun. He is acting on an observable, articulable violation of a specific law. That distinction is the entire difference between the ruling protecting you and the ruling having no relevance to your situation whatsoever. Know your state's storage requirements before you start the engine. This is not optional preparation. This is the minimum standard of responsible carry. This is the most misunderstood limitation in the entire ruling, and it is the one most likely to affect an otherwise law-abiding gun owner. The court ruled that a legal firearm cannot be the sole justification for a search. It did not rule that a legal firearm cannot be one factor among several. The moment other elements enter your traffic, stop a nervous passenger giving inconsistent answers, an odor of a controlled substance, contradictory statements about your destination. The legal calculation changes entirely. The officer is no longer arguing he searched because of the gun. He is arguing he searched because the gun, combined with everything else he observed collectively, created probable cause. He may be legally correct. The automobile exception established in Carroll v. United States back in 1925 has never been overturned. Officers can still search vehicles when they have genuine probable cause. What this ruling narrows is the definition of what counts as probable cause, not the authority to act on it once it exists. One right protected, 3 ways to lose it. Know all 3 before you drive anywhere. We have covered the ruling. We have covered the trapdoors. Now I need to tell you about the single most dangerous moment of any traffic stop involving a firearm, and it is not the moment you think it is. It is not when the officer sees the gun. It is not when he runs your plates. It is not even when he asks for your license and registration. The most dangerous moment is when he already knows he does not have enough to legally justify a search, and he asks you to give him permission anyway. It sounds exactly like this. Since you have a firearm in the vehicle just for my safety and yours, do you mind if I take a quick look through the car? He is calm. He sounds reasonable. He sounds like he is doing his job. Every instinct you have as a cooperative, law-abiding person tells you to say yes to prove you have nothing to hide, to keep things friendly, to make the stop end faster. Do not say yes. The moment those words leave your mouth, the 9-0 Supreme Court ruling becomes completely irrelevant to your situation. You have just handed the officer a blank check. Glove box, center console, trunk, your personal bags, all of it. Consent overrides the court. This is not a legal technicality. This is the foundational principle established in Schneckloth v. Beaumonte in 1973, and it has never been overturned. Voluntary consent to a search waives your Fourth Amendment protection entirely. That waiver cannot be undone in a courtroom, not even with the most favorable Supreme Court ruling in a generation sitting behind you. There is also the plain view doctrine to consider. If you open your door, your trunk, or your glove box voluntarily, and an officer observes anything questionable in plain sight, that observation is now legally obtained evidence completely independent of whether you consented to a search. You do not have to say yes to a search to give an officer what he needs. You only have to be careless about what he can see. Research consistently shows that the majority of people consent to vehicle searches when asked by law enforcement, not because they are legally required to, but because the social pressure of that moment overwhelms their awareness of their rights. The psychological mechanics are straightforward. Refusal feels like guilt. Compliance feels like innocence. Law enforcement is trained to leverage exactly that instinct. Your response is 7 words. I do not consent to a search. Not aggressive, not confrontational, not a lecture about the Constitution. 7 words, calm tone, full stop, then silence. The ruling is the shield. Consent hands that shield directly to the officer. Do not hand it over. Everything we have covered until this point is theory. This is the part that keeps you out of a courtroom. Here is your complete protocol step by step. From the moment those lights appear in your mirror to the moment the stop ends, signal. Slow down deliberately. Move to the right shoulder without hesitation. A delayed or uncertain pullover creates tension and suspicion before you have said a single word. Your first communication with that officer begins the moment he observes your vehicle's response to his lights. Turn off the engine. Roll down your driver's side window completely. If you have tinted rear windows, roll those down too. This removes visual uncertainty that makes officers tense before they reach your door. If it is nighttime, turn on your interior dome light. Then place both hands flat on top of the steering wheel and keep them there. Do not reach for your registration. Do not reach for your wallet. Do not move until the officer is at your window. When the officer asks for your license and registration, do not immediately move. If your firearm is anywhere near your document storage area, an unannounced movement toward that location is exactly how calm interactions become dangerous ones. Speak first. Tell the officer you have a legally registered firearm. Tell him where it is located and ask how he would like you to proceed. That one sentence does three things simultaneously. It demonstrates full cooperation. It eliminates surprise, and it places the decision in his hands. 12 states currently require you to proactively disclose that you are carrying the moment you make contact with law enforcement. Those states include Alaska, Arkansas, Louisiana, Michigan, Nebraska, North Carolina, and Texas, among others. If your state mandates disclosure, comply immediately. If it does not, you have no legal obligation to volunteer that information unless directly asked. But if you are asked directly, one lie transforms a routine stop into a criminal situation faster than almost anything else that can happen at that window. I do not consent to a search. Nothing more. Do not argue. Do not reference any court ruling. Do not explain your reasoning. If the officer responds with pressure, if you have nothing to hide, why not let me look? Recognize that for exactly what it is, a psychological technique designed to make refusal feel like guilt. Respond once, calmly, then stop talking. Silence is a protected exercise of your Fifth Amendment rights. Do not fill quiet moments with nervous explanation. Most people talk their way into a search. Every sentence you volunteer is a potential building block toward probable cause. State clearly, once loudly enough for his body camera to capture, "I do not consent to this search." Then stop. Do not repeat it. Do not escalate. Your composure in that moment is the foundation of every legal challenge that follows. Evidence discovered in an unlawful search becomes potentially suppressible in court, but only if your conduct gives an attorney something clean to work with. Pull over somewhere safe the moment the stop ends. Write down the exact time and location, the officer's name and badge number, every word exchanged, whether you consented or refused, what justification, if any, was offered for the search, and what was or was not found. Human memory degrades faster than most people realize. Specific, contemporaneous documentation is what attorneys use to build winning cases. Vague recollections are what cases are lost on. 8 steps. Every one of them matters. Not one of them is optional. Here is the question nobody in this conversation seems willing to ask out loud. The Supreme Court issues a ruling. 9 justices sign it. It is published, distributed, and reported on within hours. But here is what does not happen automatically, and what I think deserves far more attention than it is currently receiving. That ruling does not deploy itself to the approximately 18,000 individual law enforcement agencies operating across the United States. It does not update training manuals overnight. It does not appear in the morning briefing of every patrol officer in every county in every state the following Tuesday. The pipeline between a Supreme Court opinion and a changed interaction on the side of a road runs through department policy, supervisor training, legal counsel review, and institutional culture. And that pipeline moves extraordinarily slowly. So here's what I want you to consider as a genuine question, not a conspiracy, not an accusation. What is the realistic timeline between this ruling being issued and every officer who might encounter a legal gun owner in a vehicle actually understanding its implications and applying them correctly? Nobody has a satisfying answer to that question. There is also a structural reality worth naming. When legal language is ambiguous, when enforcement is inconsistent, when the gap between written law and applied law is wide, the people with resources navigate that gap with attorneys. The people without resources navigate it alone in real time on the side of a road. That is not a political statement. That is how legal systems function under pressure. And then there is the emerging frontier that this ruling does not touch at all. 28 states now have permitless carry laws. When no permit is required, the mechanism an officer has historically used to verify legal possession during a traffic stop, asking to see the permit, no longer applies the same way. That is unresolved legal territory, and unresolved legal territory always has consequences. Let me bring everything together, because if you have stayed with me through this entire video, you deserve a clear summary of exactly where things stand. The 9-0 ruling is real. It is significant. It draws a clear constitutional line that the mere presence of a legally possessed firearm cannot by itself justify a warrantless search of your vehicle. That matters. Do not let anyone minimize it. But it is not a force field. It is not a get-out-of-jail card you can hand through a car window. It is a legal principle that operates inside a system, and that system has trapdoors, pressure points, and gaps that this ruling does not close. Your prohibited status, your storage compliance, the totality of circumstances at your stop, and the single word sure in response to a consent request. Any one of those four things can make this ruling completely irrelevant to your specific situation before the officer finishes his sentence. Know the ruling, know its limits. It's know your state's laws, know the 8 steps, and know that your body camera documentation and your silence are more powerful practical tools than any court opinion because they are the things an attorney can actually use when it matters. Now, here's the question I want to leave you with because I think it is the one that does not get asked enough. If a unanimous Supreme Court had to intervene to stop lower courts from using legal gun ownership as justification for searches, what does that tell us about where the pressure on these rights is actually coming from? I will be exploring exactly that in the next video, including developments at the state level that suggest this legal question is far from settled. If you are not subscribed, this is the moment. Hit the bell, because when the next ruling drops or the next case files, you will want to know about it before it affects you, not after. Share this with one gun owner, not for my numbers, because they need to know what you now know. I will see you in the next.